You work on the water. You've spent years offshore, on barges, on vessels. You just got hurt. Somebody told you the Jones Act protects workers like you, but then your employer told you the Jones Act does not cover you, that your seaman status does not qualify. Now you do not know who to believe. The Jones Act seaman status test is a specific legal determination, not a job title. Your employer has every financial reason to tell you that you do not qualify. An independent maritime attorney can tell you whether they are right. Here's the truth. Seaman status under the Jones Act is a legal determination, not a job title. It does not matter what your employer calls your position or what it says on your work order. What matters is whether you meet the legal definition of a seaman under federal maritime law. That test has ended valid claims from workers who actually qualified, and it has revealed rights for workers who never knew they had them. By the time we're done here, you will understand the two-part legal test courts use to determine seaman status. The vessel connection requirement that trips people up more than any other element, what the 30% rule means and why it is a guideline rather than a hard number, the identifiable fleet doctrine, and how it applies to workers who rotate between multiple vessels, what structures actually count as vessels under the federal maritime law, and how to approach your situation if the answer is not clear-cut. Federal courts apply a two-part test to determine whether someone qualifies as a Jones Act seaman. The first part, you must contribute to the function of a vessel or to the accomplishment of its mission. This is generally the easier element to satisfy. If your work has anything to do with the vessel's operation, its navigation, or the work the vessel is there to perform, you likely satisfy this element. Deckhands, engineers, cooks on commercial vessels, anchor handlers, crane operators on offshore supply vessels, workers who manage cargo as part of the vessel operation. The functional contribution test is broad, and most workers who spend meaningful time on working vessels can meet it without much difficulty. The second part is where the real legal battles happens. You must have substantial connection to a vessel or to an identifiable fleet of vessels in navigation, and that connection must be substantial in both duration and nature. This is the element employers challenge most aggressively, and is where seaman status gets decided. The vessel connection and the 30% rule. Courts have developed what is sometimes called the 30% rule as a practical working guideline. If a worker spends less than 30% of their total working time connected to a vessel or fleet of vessels, courts treat that as a strong indicator they are not a Jones Act seaman. Consistently spending more than 30% of your working time on a vessel's operations is a meaningful indicator, but courts also look at the nature of that connection, whether your work actually exposes you to the perils of the sea the Jones Act was designed to address. 30% is a guideline, not a hard legal threshold written into the statute. Courts look at the full picture of the employment relationship. The nature of the connection matters alongside its duration. A worker who spends 28% of their time on a vessel, but whose entire professional work is vessel-based, may have a stronger claim than someone who technically clears 35%, but whose vessel time is incidental to a primarily land-based job. The totality of the circumstances drives the analysis, not a single percentage. If you rotate between multiple vessels owned by the same company or vessels that are operated interchangeably under common ownership or operational control for the same work purposes, courts may treat all of those vessels together as an identifiable fleet. Your time across all vessels in that fleet can be combined when you calculate your vessel connection percentage. This doctrine matters enormously for maritime workers who do not spend all their time on a single vessel, but whose entire professional life is organized around vessel operations. What counts as a vessel under the law? Not everything that floats is a vessel for Jones Act purpose. This distinction is one of the most commonly misunderstood points in maritime law, and getting it wrong determines whether you have a Jones Act claim or something else entirely. A tugboat is a vessel. A barge actively moving cargo on navigable waters is a vessel. An offshore supply vessel is a vessel. A drill ship that transits between drilling locations is a vessel. A semi-submersible rig that moves between sites is generally treated as a vessel. Commercial fishing boat is a vessel. These structures are designed and used as a means of transportation on water, which is the core definition. A fixed offshore platform, permanently anchored to the seabed is generally not a vessel. A ship in dry dock that has been permanently removed from navigation is generally not a vessel. Floating structures that function like fixed land-based facilities rather than transportation platforms are generally not vessels. Whether your specific structure qualifies is a fact-specific determination courts have been working through for decades. One of the most common questions I hear is whether someone who works on an offshore oil platform qualifies as a Jones Act seaman. The honest answer depends entirely on what kind of structure you are describing. A fixed platform permanently anchored to a seabed is generally not a vessel, and workers there typically fall under a different federal framework. Some mobile offshore drilling units may be treated as vessel, but permanently moored floating facilities are not. Thinking of a spar or a tension leg platform that never moves are often not treated as vessels under maritime law. The legal distinction between mobile structures and permanently fixed or permanently moored ones is where most of the real legal fighting happens. When your seaman status is disputed, if you are in a situation where your employer is telling you the Jones Act does not cover you, do not accept that without independent verification from a maritime lawyer. Being misclassified and accepting a lower value compensation framework is exactly what happens to the injured workers who take the employer's word on a question the employer has every financial reason to answer a certain way. If your status is disputed, there are practical steps you can take immediately. Start gathering your own employment records, timesheets, hitch logs, work orders, or any documentation showing how much time you actually spent aboard the vessel versus onshore. Identify any coworkers who can speak to what your day-to-day work involved and where you spent the majority of your time. Do not let the employer's internal classification of your job title determine the legal outcome. The classification that matters is one that a court makes based on the actual facts of your employment, and those facts are worth documenting before records get harder to access. Borrowed servants and dual employment. There is one more situation worth knowing about that comes out more often in offshore work than people expect. Some maritime workers are employed by one company but do their actual work for another, placed as contractors or temporary workers on a vessel operated by a different employer. Maritime law has a doctrine called the borrowed servant doctrine that addresses how Jones Act liability is allocated in these arrangements. The key point is that being employed by a staffing company that places you on a vessel does not automatically mean you lack Jones Act rights against the vessel operator. The analysis of who qualifies as your employer under maritime law is more nuanced than the contract language suggests. A vessel operator may be treated as your Jones Act employer, even if you are technically on a staffing company's payroll, depending on who controls your work. If you are working as a contract or temporary worker on a vessel, do not assume the employment arrangement removes your Jones Act rights. Have that conversation with a maritime lawyer. This issue comes up with increasing frequency in Gulf Coast offshore work, as more companies use contract staffing arrangements, and it's an area where accepting the employer's characterization of your legal status without independent review can cost you significantly. Once you know you're covered, the clock matters. The Jones Act has a 3-year filing deadline, with some traps people miss. Watch the statute of limitation video next so you know exactly where you stand on timing. Workers' comp was not designed for maritime workers, and accepting it when you should be under the Jones Act is one of the most expensive mistakes an injured seaman can make. If you want to talk through your specific situation, our information is in the description. Have you been told the Jones Act does not cover you? Tell me what kind of work you do in the comments, and I will give you my honest read.